Welcome back to Insight. We are joined now by Dave Farnbauch from the Sweeney Law Firm. So, Dave, there are some medical malpractice laws that are unique to Indiana, and there have been a number of news stories lately regarding medical errors and medical malpractice. So tell us about those.
Well, I mean, we've seen a lot of news stories lately that were sort of the issue of medical malpractice has come to the forefront. There was a big news story a few weeks back about a local pain physician who the Attorney General is pursuing, and there's been the epidemic that we had in Massachusetts with the fungal meningitis, and so it's been a lot of news lately about the topic of medical malpractice. And what I thought we'd do today is spend a little bit of time explaining to people maybe some of the laws that govern malpractice here in the state of Indiana that are surprising when I talk to people, are unique to Indiana. Most people don't realize that in the state of Indiana we have a cap on medical malpractice damages. We have
so
a cap.
You can only sue for so much.
Right. It's $1,250,000. And that's shocking when I tell a lot of people. For instance, we handle cases that involve we call them birth injury cases, where a little baby during the delivery can be harmed and can require a lifetime of medical treatment that could realistically runs in the tens of millions of dollars. In Indiana, we have a hard cap of $1,250,000, so it doesn't matter, you know, how much harm is caused. You're capped out at $1,250,000. And when I tell people that, they're completely shocked. I mean, how could that be, that there could be this ceiling on the amount of damages irrespective of the amount of harm?
Is there anything that somebody can do about that if they're in that situation?
No. In fact, there was a recent case where attorneys tried to challenge the cap, and the Indiana Supreme Court, it was primarily on procedural grounds, just ruled that the cap is going to stay in place. So it's been the law since 1976. We had a cap on damages. They've adjusted it at different time frames. But the current cap is $1,250,000, which with today's medical cost is woefully inadequate. The other interesting thing that's unique about Indiana medical malpractice law is the notion that we have a medical review panel that decides on the merits of cases before you can file a lawsuit. It's the only area of law that I'm aware of in Indiana where you're sort of judged by your peers. When you file a medical malpractice lawsuit in the state of Indiana, a panel, if you sue physicians, a panel of 3 physicians is convened to decide whether the case has merits. And that's unique. You know, if you sue a lawyer, there's not a panel of 3 lawyers or an architect. But if you sue a physician in the state of Indiana, there's a medical review panel that's formed to decide the merits of the case.
Well, and I would think, just in theory, that that's a little harder to get past, because obviously they're cognizant of the fact that these are their peers in their industry. So I would think it's almost, you got to go 2 steps, and that first step I would think is challenging. Well,
it is challenging because it's a situation where a lot of times physicians know one another, and they attend the same you know, seminars and whatnot. So it is difficult. I think cases that tend to fall into what we call the gray area of medical malpractice, I think a lot of times physicians do get the benefit of the doubt with their peers on the medical review panel, which makes it a lot more challenging for patients and consumers to try to get justice if there's a medical malpractice case. So we have some very unique and challenging laws that present some hurdles to patients when they are the victim of medical malpractice in the state of Indiana.
Well, and obviously you're the expert on that, and it is very hard to digest all of the rules and what you need to do. So if somebody thinks they have a medical malpractice suit, definitely the best thing to do is to contact you guys, because you can at least tell them whether or not they should proceed.
Yeah, I mean, oftentimes we get a lot of calls and we explain to people, look, we're sorry for what happened to you, but it appears that there's no malpractice. But occasionally we do get calls where the cases are meritorious, and so the only way you're ever going to find out as to whether you have a meritorious, winnable medical malpractice is to call an attorney who specializes in that area.
All right. Well, if you have a question about medical malpractice, give the guys at Sweeney Law Firm a call. They can help you out today. 420-3137, or check them out online, SweeneyLawFirm.com.